Welcome to Navigating Estate Planning with Caress Law. I am Tammi Caress, founder of Caress Law. And today, my goal is to help you understand the power of disclaimers in shaping your legacy. We're going to learn about what a disclaimer is and how it can be used. It's a common estate planning tool that can be used to minimize estate taxes and therefore maximize the full potential of your inheritance strategy. And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much. Let's get started. Why a disclaimer and what is it? So I'm talking about this today because it is a common estate plan to implement a disclaimer type of action in your documents so that we can minimize estate taxes assessed. Now, this is a plan that's typically implemented when you are married, and it's implemented jointly between you and your spouse. You can implement this plan for future generations' estate tax savings, but typically today I'm really going to talk about how we can minimize the overall estate taxes when a married couple passes away, and usually their inheritance goes to children or nieces and nephews and so forth. Just to give you some background, disclaimer means that it is a person who decides they don't want to inherit. So an example is if you give your surviving spouse your assets through your estate plan at death, the surviving spouse can say, I don't want some of those assets. And by doing a disclaimer, that surviving spouse is treated as if he or she died before their spouse. So in estate plans, we always have alternate takers. Who is going to inherit should this person die before? Usually it's a testator in a will, or maybe it's the trustor or grantor of a trust. So we have alternate provisions. And when a person disclaims, the document will say who inherits if this person passed away before me. And by disclaimer, that person disclaiming is treated as if they passed away. And so we look to alternate beneficiaries. Don't worry, we're going to continue going through what a disclaimer is. By the way, today I am going to be referring to the first spouse. That usually is the spouse who passes away first. And then I'm also referring to the surviving spouse. That obviously is the spouse that survives. I may use a term called decedent. That's the person who's passed away as well. So to get a really good foundation of how we use disclaimers to minimize estate taxes, we need to talk about the estate tax. So the estate tax is a death tax. It's a tax assessed upon assets of a deceased person. So it's only assessed at death. And it's only assessed on assets over a certain amount. So every state who has an estate tax has an amount, a threshold that the estate value needs to be at before they're actually assessed a tax and required to file an estate tax return. So, since I practice law in both Oregon and Washington, I'm going to be using those examples today. In Oregon, we have a $1 million exemption. That means that the first $1 million in a person's estate is exempt from estate taxes. So if a person passes away and we value all of their assets and the total value of their assets is less than $1 million in the state of Oregon, their estate is not subject to the estate tax. They don't have to file a tax, an estate tax return. Washington has an exemption amount of $2.193 million. And I am just going to round up for purposes of this podcast to 2.2 just to make it easier. That is the exempt amount in Washington, the amount that can pass before it is taxed or subject to the estate tax. So those are actually the thresholds as well. So if a Washingtonian passes away and they have a $2 million estate, it is under that $2.2 million exemptions, and they are not, or their estate is not required to file an estate tax return, and there's no taxes due. Now, there is a federal estate tax, but each person has a $13.61 million exemption. So before any person is subject to the federal estate tax, their estate needs to be over $13.61 million. So on the federal level, usually it's the ultra wealthy who are getting assessed this type of tax. Each person has an exemption. It's not per couple. Okay. So in my example, I use Bill and Mary. They are a married couple. That's who I'm going to be referring to. Some of you who listen to my webinars and so forth are probably pretty familiar with Bill and Mary. So Bill and Mary have an estate plan. Bill wants all of his assets to go to Mary, and he wants to minimize estate taxes payable at death. So he prepares a will, and the will says everything goes to Mary. If Mary doesn't survive Bill, then his will says everything goes to my children in equal shares. Okay. So Bill passes away. Bill and Mary's combined asset total is $4 million. Bill's portion of their combined asset title is $2 million, so 50%. So when we're looking to see if Bill's estate is subject to the estate tax, we're looking at his portion of the assets that he owns. So here he owns 50% of the assets. So only 50%, that $2 million number is what we are looking at. So if he passes away, or when he passes away, his estate plan gives everything to Mary. Mary accepts everything. Her total estate value is now $4 million because she inherited Bill's 50% share of the assets. So her estate value is now $4 million. Now, because Bill and Mary are Oregonians, the exemption amount is $1 million. So $1 million can pass tax-free. Bill's estate is required to file an estate tax return. Now, there is something called a marital deduction. Anything that goes outright to Mary in Bill's estate gets a deduction on the estate tax return. So in this example, Bill's will gives everything to Mary. She inherits it. There is an estate tax return that is required to be filed, but there's no estate tax due. And that is because Mary is Bill's spouse and there's a marital deduction, and therefore her inheritance from Bill will not be subject to the estate tax yet. Okay? Hope you're following me. Now Mary is worth $4 million. Mary now passes away. We're going to look at Mary did not remarry. Her gross estate is $4 million. She lives in Oregon. So the estate tax assessed on Mary's estate looks like this. Mary's exemption is $1 million. So her gross estate value of $4 million is reduced by $1 million because the first $1 million is not taxed. So Mary's taxable estate is $3 million. Oregon's estate tax is assessed at between 10 and 16%. So the Oregon estate tax assessed in Mary's estate is $312,500. It's a pretty hefty tax going to the state of Oregon when Mary passes away. All right. So what if they actually implemented some tax planning, estate tax planning in their documents? What would that look like? When Bill passed away, he had his estate plan. It would be a will or a trust, likely, that was set up prior to his death that said, I give all my assets to Mary if Mary survives me. However, if Mary disclaims any of the assets, then the assets she disclaims is going to be set aside and put into an estate tax exempt trust. Now, this trust is irrevocable, meaning Mary can't change it, but Mary gets all the income for her lifetime, and she can use the principal of this estate tax exempt trust for her health, education, maintenance, and support in her custom manner of living. And Mary can also be the trustee of this trust. Mary has complete control over the trust, access to the trust, and can use it for those very broad purposes we set forth in the trust. But when Mary passes away, anything that is in that estate tax exempt trust is not subject to estate taxes when Mary dies. Okay, so I'm going to run through what this looks like with this plan in place. So Bill estate is $2 million of a combined estate for Bill and Mary of $4 million. His estate is $2 million. He dies. He gives his assets through his estate plan or says that they go to Mary. Mary says, I don't want to inherit all these assets. So she prepares a disclaimer, disclaiming the assets. She's basically saying, I don't want them. And then the document says, okay, if Mary does this, then we're going to move the disclaimed assets into this estate tax exempt trust, which Mary has access to. Now, why would Mary do this? Mary would do this because we are intentionally disclaiming assets to shelter those assets from estate taxation. And Mary is going to disclaim the assets up to the state level, in this example, exemption amount. So she lives in Oregon, or Bill lives in Oregon. The exemption amount is $1 million. So Mary's going to disclaim $1 million of Bill's assets. Those assets are going to be in this estate tax exempt trust for Mary's use and benefit during her lifetime. So they put this in place. By the way, the remaining $1 million in Bill's estate, Mary did not disclaim. So through the estate plan, she is going to inherit that $1 million. So let's see what happens now with the estate tax when Mary passes away. So Mary's estate value is $3 million. That $3 million consists of the $2 million that she already owned, the $1 million that she inherited from Bill. Okay, so her estate, because of this planning, is only $3 million, not $4, as in the prior example. Mary has an estate tax exemption of $1 million. So Mary's taxable estate is $2 million. In the prior example, it was $3 million. So her taxable estate is decreased by $1 million. The estate tax assessed in the state of Oregon is $205,000. That is a savings of estate taxes of $107,500. So by implementing this, what I call disclaimer type of plan, Mary and Bill have effectively saved $107,000 roughly in estate taxes. I think that's a pretty good deal, right? So that's what it means when we're disclaiming assets. And I do want to share with you and go through an example if Bill and Mary are Washington residents and subject to the Washington estate tax, because the amount of estate tax savings is significant in this example. So in this example, Bill and Mary implemented this disclaimer type planning. When Bill passed away, Mary disclaimed $2 million of Bill's assets. So basically, Mary disclaimed everything that Bill was going to give her because his estate value is $2 million. By the way, because Bill's estate as a Washingtonian is under $2.2 million when he passed, there was no estate tax filing, no estate tax due. Okay. But he still implemented this plan, this disclaimer type of plan. So Mary said, oh, well, I'm going to disclaim all the assets that Bill is giving to me so that those assets go into the estate tax exempt trust, which again, Mary is the sole beneficiary of this trust and has access to the assets for her health, education, maintenance, and support in her custom standard of living. So when Mary passes away, her estate is worth $2 million. That was her portion of Bill's, and her estate was $2 million. The $2 million of Bill's estate is not included in her gross estate because it's in this tax sheltering exempt trust. So now Mary's estate is a $2 million gross estate. She is a Washington resident. The threshold for Mary to be subject to the estate tax is $2.2 million. So Mary's estate does not have to file an estate tax return, and Mary's estate gets to give $2 million to her children. And guess what? The estate tax exempt trust funded with Bill's assets pass to their children free of estate tax. That's a pretty good deal, right? I probably should have talked to you about what the tax would have been if they did not put this plan in place. So if they did not put this plan in place and they were Washingtonians, Mary would have passed away with a $4 million estate. She would have had a $2.2 million exemption that's not subject to tax. Therefore, she would end up with a taxable estate of $1.8 million. And in Washington, the tax assessed would have been $212,000. So we went from a plan that would assess an estate tax of $212,000 to a plan that makes that estate tax zero, nothing. So pretty significant, it's pretty powerful. So why this type of plan and why a disclaimer? Like I understand, I explained it's to minimize estate taxes. There are other ways to minimize estate taxes in a plan. A lot of times, if you are a blended family, you're on your second marriage and maybe you have kids from a prior marriage, we may want to change the plan up a little bit to accomplish the same goals, but ensure that your kids inherit once your spouse is gone. I'm not talking about those today, so there are other ways to implement this plan. But the reason I like disclaimer planning is we don't have to make decisions as to whether we need to fund this other tax sheltering trust until the first spouse passes. And when I say make decisions, It will allow us to be flexible and account for the changing tax laws. So an example could be that maybe Oregon says, well, we're not going to tax people's estates unless their estates are valued more than $5 million. Well, if that's the case, and Bill and Mary's total estate value is $4 million, maybe we don't want to do a disclaimer to this estate tax sheltering trust because there's no reason to. We're going to escape having to pay estate taxes due to the value of their estate. So that's some of the reasons we like this type of planning. It could also mean that maybe when Bill passed away, Mary decides to move to California. Guess what? California doesn't have an estate tax. So when Mary moves and takes all of Bill's assets and her own with her to California, there'd be no estate tax assessed at her death. So Mary doesn't really need to do this kind of planning or disclaim assets to save estate taxes because she's moving to a jurisdiction that's not going to tax her in that regard. So there are lots of reasons to do this plan, but this is why I like this kind of plan. However, there are some things that you really need to know about if you are going to put this kind of plan in place. First, when Bill passed away, Mary, before she does anything with the assets, should call her attorney. That is because Mary has 9 months to disclaim. If she waits longer than 9 months, then she loses out on the ability to disclaim the assets, and therefore we cannot implement this estate tax minimization technique. So there's a 9-month window. The other thing that Mary cannot do or should not do is she should not move assets into her own name prior to disclaiming them. Okay, so an example is Bill and Mary own a joint account together. Mary calls her financial advisor, says Bill has passed away, and the financial advisor says, okay, this account is a joint account. That means, Mary, you as a surviving joint owner, become the sole owner of this account. I'm going to get the paperwork together for you to move this account into your sole name, and Bill will no longer be on the account now that he's passed. That's a reasonable step. However, if you have this type of plan in place, it is going to disqualify Mary from disclaiming that asset. And that is because if she takes ownership of that asset, meaning that asset goes from Bill and Mary jointly to Mary alone, and she hadn't disclaimed it, that now disqualifies her from using that asset or disclaiming it because she already received the ownership. So the reason I used the example of the financial advisor is we actually see this quite a bit. Typically, it's with people who are coming to us to administer an estate or settle an estate when their loved one passes away, and we haven't worked with them in the past. Those people oftentimes start taking steps without talking to the attorney. The financial advisor doesn't know the attorney, and the financial advisor is just doing what the account says to do. And they don't know that they have this plan in place. And I have seen many clients who have come to us after 9 months has passed, or they have already retitled the assets into their own name, and they're coming to us for help. And we look at everything and say, it's too late. You've now taken ownership of all these assets. You've lost the opportunity to disclaim. And if this is Bill and Mary, if Mary decided not to hire an attorney or work with an attorney and kind of do things on her own, she lost the ability to, if she's a Washingtonian, escape the estate taxes 100% or save over $100,000 in estate tax if she was an Oregon resident when she died. So extremely important to talk with and work with your attorney. I've just seen this time and time again, and this planning it's just been wasted if you don't get the right people involved. When we work with you on your estate plan, part of our process is to call your team. Your team is your attorney, your estate planning attorney. If you have business, it's a business attorney as well. It's your financial advisor, and it's your CPA. With my clients, I always reach out to their team if they have those players on their team, because I want to make sure that the financial advisor understands the plan. And by the way, I get such great information from my financial advisors that will help me do a really good plan for the client. So this ensures that we're all on the same page, and we're going to protect you and make sure that the plan that you have put in place actually works when the time comes. Okay, I hope this has been helpful for you. This is just one plan, but it is a very common plan because it's extremely flexible and I use it quite a bit. It is a plan that is common, I should say, to put in place. If you have any questions or topics you'd like us to cover in future episodes, please feel free to reach out. Your feedback helps us tailor our content to better serve you and your needs. Thank you for joining me today. I hope you found this topic insightful. And if you enjoy our podcast and found it valuable, I'd really appreciate it if you could take a moment and leave us a 5-star review on Google. Your feedback helps us reach more listeners and continue to provide content on estate planning and inheritance. I have links in the show notes below. Remember, your estate planning is a journey, something that will change over time and should be consistently reviewed when you have major life changes occur, and I would say annually or every couple years. All right. Thank you. Goodbye for now.